Hello, Chinmay sir.
Just 1 second, sir.
Yes, yes. Yeah, sure.
So you good? Hi.
Can we start?
Yes, sure.
Yeah, within 2 minutes, we'll start. Kranti ma'am?
The schedule time is 11, right?
Right, right.
Let me know once we start. I'll start the video.
Yes, 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 sure, sure, sure. Shall we start, ma'am?
We can start. Only thing is that I think time is 11, so participants may join up to 11 o'clock, right?
Let me wait till 11, I think.
Yeah, because it's now means for 11, 10 minutes are there. So
Correct.
more participants will come, I think.
Sure. We'll start at 11, I think.
Yeah. Till that time, sir, you can share the screen so that it will go on. Saurabh, sir.
Yes, sir. Yes, ma'am. Yes, ma'am. Okay, shall we start, ma'am?
Yeah, please, we
Yes.
can start.
Yes.
Chinmay sir is there?
Yes, I'm here.
Yeah.
Okay, I again welcome you all to Marathwada Mitra Mandal Shankarrao Chavan Law College, Pune, which is affiliated to Savitribai Phule Pune University and accredited with A grade by NAC, to the international webinar series Law and Opportunities Through Young Brains. So young brain from around the world discussing international opportunities in various fields of law. Yesterday, we have seen that one of the professor from IIT Kharagpur, she talked about IPR concerns, IP strategies, and entrepreneurship. Along with that, yesterday we also have visited to the international cooperation and the professor of Peking University, who was alumnus of the Yale Law School, also discuss about the international cooperation. Today, we are having amongst us Advocate Dr. Chinmay Sureshchandra Bhosale from India and Advocate Upendra Dulal from Nepal. He'll be joining by 11. Chinmay sir will be talking about a changing landscape of criminality and the role of mediation. Where Upendra Dulal sir, he's talking about international investment law and international opportunities. So I hand over to Kranti ma'am to continue with the function.
Yeah, thank you, Saurabh sir. It is my pleasure to welcome Advocate Chinmay Bhosale sir. It is pleasure to have you with us. Today you will be talking on one of the important topic. This is international webinar, and through this webinar we are trying to throw light on various issues and opportunities which are available for budding lawyers at an international level. I hope all participants are enjoying this international webinar, and this is today is the second day of this webinar. All resource persons, they are enriched with knowledge and they are trying their level best to give guidance to the guidance to students. So once again, I welcome you, Chinmay sir, all participants and faculty members of Shankarrao Chavan Law College. And without taking much time, I would request to proceed for today's session. Thank you.
Thank you, ma'am. Now I request Krishna ma'am to address the gathering.
Thank you, Saurabh sir. For this session, we have with us a young and dynamic advocate, Dr. Chinmay Sureshchandra Bhosale sir. Sir has completed his graduation and post-graduation from Pune University, where he secured a gold medal. Sir has completed his PhD in law from Pune University. He is one of the youngest advocate in India who have conferred with the PhD in law. He is practicing in the field of corporate criminality, commercial litigation, and dispute resolution. His specialization is in economic offenses and white-collar crimes, and he has handled many matters in it. He appeared in many famous matters such as Adarsh Scam, 2G trial, Hassan Ali case, Marvel Police firing on Expressway, Santosh Mane's case, and the list is unending. He worked extensively in the field of legal technology and multiple startups, and as an advisor for them, including Forbes as well. He is advisor to many banks, real estate companies, builders, and multinational companies, etc. Definitely, list is unending and the time is constrained. So without wasting much time, I now request to Dr. Chinmay sir to proceed with this session.
A very good morning to all of you, and thank you for a gracious introduction. So first of all, I would like to congratulate SCLC for this very good initiative in which the young students specifically, or even the lawyers who have recently passed out, do not have enough knowledge about what are the options before them while they enter the field, be it academics or be it the profession. And it's a very noble gesture on your part to have been trying to give them some headway or some guiding path. Saying that, I'll start with my session for the day. So as you all rightly know, the topic for the current discussion. So I'll like to phase it in 4 different segments in which hopefully I'll be in a position to speak about it in a comfortable way, in which you'll understand the logic, the history, the present and the future with respect to corporate criminality and criminal laws or crimes as such in India, and the opportunities which it gets along with it, and also the role of mediation. How does it come into picture in criminality and criminal law as such now? So let's start with part 1 of it, which is the historical perspective, which we can discuss briefly, so that you will get a idea of how the opportunities in this field are changing dynamically. So essentially, Indian criminal law is dominated by the Indian Penal Code, which essentially started with its drafting stage in 1833 by the then British government, which was ruling over India. And by the early 1853, the drafting was complete, and by 1860, the Indian Penal Code was passed and it was implemented as such in the country. So that itself tells you the perspective by which the practice with respect to criminal law did survive in the past, say 65, 70 years, if not till today, in India. The basis being pre-independence logics, pre-independence laws, and pre-independence social norms, which dictated the laws, criminal laws at that particular point in time. So what does IPC broadly specify? So it broadly specifies all the laws in the country which were necessary to be protected or governed with respect to criminal acts way back in we can say right from 1833 to 1860. No doubt there was some vision showed over there with respect to various fines that were instituted, which today we feel trivial, say 500 rupees or 1,000 rupees, which we read today are the amount of fines haven't been changed, and we feel it's quite outrageous to have such petty amounts as fines, because they won't be of any detriment. But if you go on to think that in 1833, 1,000 rupees was a lot of amount, and it definitely was a deterrent. So going beyond that, if you observe the entire penal code, it was basically restricted more to either government actions against the government, so that the British probably could rule the country well. And other than that, it was essentially about bodily offenses. And that was the sum and substance of the entire legal practice, which was dominated right from pre-independence to say up till 5 years ago, probably in India as well. Also the logic behind that you will need to understand, and the intention behind it you will have to understand. As I pointed out, Indian Penal Code, which dominates our criminal law, was essentially formulated by the British in a way so that they could be in a better position probably to have a hold over the country. Of course, governance was part of it, to be fair to them, but nonetheless, it was more about being in a better position to hold the country back and have stricter norms around the bodily offenses. And our country per se socially was also in a state wherein we were fighting for survival, and going beyond bodily offenses was not something which was happening very regularly. So that was broadly the perspective behind the Indian Penal Code, and that is the broad spectrum by which the entire drafting has been done, and all the offenses mentioned therein are related to. So speaking of that, how does that entail into a topic or entail into a discussion which might be of interest to people who are just entering the profession or will be entering the profession in the near future? So why am I speaking about this is that say slightly more than a decade ago, when I entered into practice, or probably 15 years ago when I started walking through through the corridors of court with legends of the bar at the criminal side, I essentially could see that criminal practice was essentially 99% dominated by bodily offenses. And that was something which was very surprising to me, being a young generation lawyer stepping into the courts, because for people of my generation, obviously now you are much younger to me, it was a surprise that people aren't thinking beyond, even if they are criminals, people aren't thinking beyond bodily offenses or doing crimes which are more about hurting the person. And I somehow strictly believed that that wasn't going to be the future of criminal law, because if you observe various countries over the globe, once and as and how the country progresses, socially as well as economically, the mind of the humans starts deviating to other ways in which they can commit crimes or they can get access to easy money. And that's how essentially any law or uh, any modus of crime is going to change. And if you want to evolve as a lawyer, you will have to be futuristic enough to understand where the trend is going to go, and you have to adapt yourself with the concerned qualities to be in the shape and position to be thriving at the futuristic laws which might come across and the practice which is thrown at you. So having said that, I'll just step a bit back, and I'll before I go on to detail the changing scope of criminality from bodily offenses to other types of offenses, be it virtual offenses, economic offenses, etc. Before I go on to that, I'll just briefly again focus on why this. So, because why am I saying this is because people might find it quite irrelevant probably, that why is it necessary to tell that organized crime or economic crimes is the present and future, because quite a few of you might have read about these cases even before you joined law or you decided to do law. But when it comes to the courts and practice in our country specifically, the pace of judiciary isn't as high or isn't as fast, and therefore if you come to the profession and you have to see what cases you're dealing with, those cases essentially might be the ones which are registered say a decade ago probably. So you need to understand the transition and why the logic of the change in the scope of criminal law. So essentially, as I said, I'll take a step back. I'll like to point out 4 different points in which how laws were restricting or flourishing, for that matter, only with respect to bodily offenses. One was the societal nature. So if you see, so obviously all of you know that laws will change as per society, and however the masses or the people are behaving and changing or evolving, the laws are going to evolve accordingly. So when the laws which are prevalent in our country were essentially drafted, they were drafted at a time wherein the society was more into a social outrage. It was more into expressing the anger bodily, and the crimes which were committed were more in the nature of bodily offenses. That was one point. Second point is that it was also the need of that time. Both, as I said, the society was in a state wherein bodily offenses were flourishing, and also the governments or the governing authorities, be it the Indian government or the British government, were facing the need to curb such bodily offenses, be it for their own gains or be it for the law and order and peace of the society. So the relevant need 100 years ago, or probably at the time of independence, was such that the criminal laws were necessitated to be concentrating on bodily offenses per se. And third is the practice which was prevalent at that point of time. So as I said, even I have seen that giants at the bar of the criminal side have had 99% of their practice revolving around bodily offenses. So if I have been in that position and I am witnessing that, obviously people of previous generations were having limited exposure and limited experience, for that matter, when it comes to evolving scope of criminal law. All that was seen in the courts of law or which was practiced was trials with respect to bodily offenses. Rarely, obviously, there were some fraud, some cheating cases wherein criminal law came into picture. However, it was, as I said, largely dominated by bodily offenses. So this was the sum and substance and the brief history and the logic of where we were at, or probably we are at, since IPC is still in force, pretty much in the same structure even today. So let's move on to the next part. So having said all of this, how is the scope of criminal law changing is one part. And secondly, why am I interested in speaking about mediation in a topic of criminal law practice and its scope? So starting with the changing scope of the criminal law and criminal practice, the society that we live in today, a sufficient section of it has gone beyond the necessitated needs of food, clothing, and shelter. And the crimes that are being committed, specifically if you see the splurt in the crimes that I'm going to mention during the global lockdown that we are all witnessing right now in the past 6 or 8 months, if we consider other countries. And that is of virtual offenses, one. Secondly, it's economic offenses. Thirdly, it's organized crime. And specifically, which the one faction of crimes which has grown multifold or has grown leaps and bounds in the past, if not a decade, at least 5 years, is corporate criminality. So crimes were always seen as something of a blue-collared segment of law, probably. And since, as I said, it was more dominated by bodily offenses. However, now if you see the rising number of crimes that are registered across the country are more prevalent on the white-collar side of it. And what do I mean by white-collar side of it? I essentially want to say that educated people who are in the corporate scenario, people who are sufficiently adept mentally, are actually putting behind their brains to commit a crime, to have an organized crime syndicate for that matter, and go ahead with the execution of it. So when we understand this changing structure of the society, so one interesting thing that I would like to share with you all, going by the generous introduction that was given for me. However, what I had witnessed while I started out in the profession around slightly more than a decade ago was that I had the option of inheriting a very giant practice at the bodily offenses crimes part of it at the bar. However, when back then I was of the opinion that bodily offenses can't be the future, and it's going to be economic offenses, virtual offenses, and offenses which you can't touch and feel probably. And those are the offenses which are going to be the future. That time probably people didn't take it as seriously, or probably didn't see it as a foreseeable or a sufficient part of criminal structure which can give you a flourishing practice. However, now as you come to 2020, you can obviously see every day when you read in the newspapers, probably most of you were too young to be reading newspapers, say 15 years ago or 20 years ago. So if you read newspapers back then, it was all about offenses which were committed for, say, murders, dacoities, robberies, etc., etc. Today, if you read the newspapers, you will read that businessmen are arrested, politicians are arrested. You'll read that partners are cheating each other in the business transactions. You'll read that excellent IT minds are putting their brains behind committing cyber frauds, and so on and so forth. So essentially, for that matter, even terrorism has gone the cyber way and the virtual way. So if you see the changing structure of the society, you'll understand what do I mean when I say that the scope of criminality has changed, and the society that we are heading into is more about these types of crimes. So what does that entail for a young lawyer, or probably to be lawyer, is that you need to be very, very you need to be abreast with all the recent developments. You need to foresee what is coming at you, and accordingly you will have to prepare yourself if you want to not just survive but flourish in the criminal practice side of the country. So let me just briefly give you the scope of practice which comes, or the opportunities that you might have in this particular section. So first comes the cyber frauds. Essentially, as you all know, the Indian Penal Code was amended to include quite a few cyber laws. We also have the Information and Technology Act, which also includes various crimes which might be committed in the information technology sector. Having said that, there are other types of laws as well, which essentially fall under corporate criminality. So if you talk about corporate criminality, so let's consider some of the frauds that you might have read nationally or internationally coming. So anyone in the world could have read about the IL&FS scam in India, which was of more than 1 lakh of crores, or various cases which were mentioned during my introduction, be it other scam. It was eventually a economic offense, be it Hassan Ali's matter, wherein more than $6 billion were allegedly misappropriated by way of hawala, again an economic offense, or corporates were involved in it, 2G scam, etc., etc. So all of that is essentially coming under corporate criminality. Day in, day out, you will also be seeing business partners defrauding each other. You'll see business transactions being done in a way to hide the real transactions. You'll see fake transactions being made in a manner to just launder money from one company to another. Probably it could also be to launder money from a bank to a certain company, and so on and so forth. So you need to be abreast with all these laws, because there are various laws which have come up. So for that matter, not just laws, various types of investigating agencies have also cropped up in the last decade, specifically to investigate such crimes. And and no more is it a state wherein you'll have to just be thorough with, say, IPC, CRPC and knowing what is police procedure. That is not going to suffice for you to have a fledgling practice at the criminal side. So what do you need to know? What do you need to understand? So if you take an example of a corporate crime, you'll also know that most of the corporates are either registered as LLPs or private limiteds, if not public limiteds. All of them come under the Ministry of Corporate Affairs. So the MCA has specifically come up with an investigating agency called SFIO. So what is SFIO? SFIO is Serious Frauds Investigating Office. So just the way a normal police or normal person feels the need to have a police station around, because anyone in the society could be committing a crime because it is that common. It has become as common in the corporate world that criminal offenses will be committed by various ways, be it virtual or be it economic, by most of the corporates. And that is the reason that the MCA has found it rightly apt to have a SFIO, that is Serious Frauds Investigating Office. So these are so this is just one example. You will also need to study what is CBI. So CBI, everyone reads in the newspapers that ABCD probe has been handed over to the CBI. So is that the only scope under which the CBI functions? The answer is no. Essentially, those are cases which are more of glorified by the media, you can say, for that matter, in which they are reported, and you will have the limited knowledge for which a Central Bureau of Investigating might be functioning. But as far as the CBI is concerned, their essential main role comes into picture when it comes to bank frauds. So there's a mandate of the RBI that any nationalized bank has or is facing any economic fraud by any corporate, any person, or internally, that has to be mandated to the Central Bureau of Investigation, and they'll be investigating it accordingly. You all might be knowing that CBI has been instituted under the Delhi Special Police Establishment Act. So that obviously is one of the acts that you'll have to be thorough with if you want to be a good criminal lawyer, or be it representing the corporates or otherwise. So we spoke about IPC, we spoke about IT Act, we spoke about SFIO, CBI. So other than that, you could also be facing, say, matters of criminality in the day-to-day world or day-to-day transactions, be it between partners, be it between transactions by the company with its customers and so on and so forth. So such matters need not necessarily be of thousands of or hundreds of crores that you read in the newspapers, or as I said, IL&FS was more than 1 lakh of crore. So it need not be as big an amount for a corporate crime or economic crime to have happened. It could be a lesser, much lesser amount. So for those amounts, essentially in our country, there's a investigating authority which has been specifically given that task, which is called the Enforcement Directorate, and their jurisdiction for a practical level and for practical reasoning has been kept at 2 crores and upwards. So any economic offense which is committed under any garb, be it by cheating people, be it by defrauding the other directors or partners in the concerned company or firm, or defrauding the investors or the clients of the concerned company, everything which is beyond the limit of 2 crore rupees will be handed over to the Enforcement Directorate. So these are the various things that you need to understand when we when you take a call, or you need to understand these opportunities when you decide to enter the profession of law as a practicing advocate in this country. So probably back, say a decade ago, or probably more than that, it was seen that if you're a criminal lawyer, or probably people who are not exposed to our field or our scope of work, feel that when it comes to a criminal lawyer, he'll be only speaking with people who are probably who have committed a murder, or alleged to have committed a murder, an attempt to murder, a theft, a robbery, a dacoity, a kidnapping, so on and so forth. But it is very surprising to know to quite a few people, the majority of people, that you can exclusively refuse to take any of these cases and still have a very flourishing criminal law practice, both mentally as well as economically. So that comes as a surprise for most of the people, but I would wish that through our discussion and through this intercourse, most of you would find that it not to be surprising that non-bodily offenses can be a practice of non-bodily offenses can be flourishing, and it is a great opportunity for practice of law in the country of India. So some of you might be thinking that it's very convenient to be speaking only about corporates, for that matter, when it comes to criminality. And that's the only part of it which has become more organized, or which has become more economic in nature, and otherwise other offenses, or say probably people from the mafia and so on and so forth, are still stuck on the bodily offenses, and that remains the main body of practice of criminal law, and the opportunity lies majorly over there. But having said that, that's not the situation, because I'll give you an example with respect to more seasoned criminals, as we call them, blue-collared people probably of the criminal practice world. So they also are more focused towards organized crimes for monetary gains now. So if you look at, since the college is stationed in Pune in Maharashtra, I'll give you an example out of Maharashtra. The Maharashtra government has come up with a law in 1999, the implementation of which started much later on a practical level. It's called MCOCA, so Maharashtra Control of Organized Crimes Act. So therein, the people who are charged by MCOCA essentially are hardened criminals with multiple offenses of similar nature against them. So having said that, people might think that this would essentially entail bodily offenses, but that's not the case. The essential ingredient to be proving or to be charging a person or a syndicate, for that matter, under MCOCA is twofold. One is that it has to be a group of people, a syndicate of crime, working together for a common purpose. And the second point is that the common purpose should be economic gain. So now everything is revolving majorly about economic gains, and even the hardened criminals are functioning in a way that they are trying to get economic gains out of their crimes, whichever they are committed. So it's of great necessity for a lawyer to flourish, and it's of great need for you to understand the opportunity here, because be it a blue collared or a white collared person, the crimes which are committed are more of a sophisticated nature, they are more of an economic nature, they are more of virtual offenses which you can't really touch and feel if you so they are more of blink and you'll miss kind of offenses, or you'll have to dig in a lot, you'll have to take out the corporate wheel and dig in more to understand that a crime was actually committed. So you'll have to have that extra cautious nature, and you'll have to have that eye as well to understand, be it even if you're representing the complainant or be it the defense counsel, you'll have to have that eye wherein you can spot the necessary ingredients, and you'll have to understand that it is not necessarily only about the conventional, say, magazines that you might be reading, the various crime report journals, or as children you might be reading various authors which write crime stories. So people are fascinated by that, and they think that criminal law or criminal practice in India is restricted to just crimes which are committed on body, but that's not the case. So these were the three parts on which I intended to speak with you. And so now I would like to merge the intention of this entire enterprise of trying to guide young lawyers into new opportunities that they might come across, and they can be well prepared to flourish in the field. So having said, having spoken about the first three parts of my interaction with you all, I like to merge it with the last part of it, which is the scope of mediation in all of this. So everyone rightly knows that any criminal offense in India, in the country of India, it is considered as an offense against the state, and as such it is registered by the state. Even if I am an aggrieved party, an offense is committed against me, it's not me versus the accused, it's the state versus the accused. And you get all the, as a complainant, you will get all the entire machinery will be at your disposal free of cost when it comes to a criminal case, because every case is considered as an offense against the state. So in spite of knowing that, and in spite of having a false notion that criminal laws probably could be restricted only to bodily offenses, now hopefully with all the interactions that we have had, I have sufficiently put forth before you all that it's not just about bodily offenses. So if it is about offenses beyond bodily offenses, is it that the only scope that a criminal lawyer will have is that of say defending you in the trial courts, taking a bail, defending you in the trials, or representing you at the appellate courts? So of course that's a major part of the life that you will be having as of today, at least in India. But as I mentioned earlier, when I spoke about economic offenses and wanting to specialize in economic offenses a decade ago, it was something which people laughed at. And that is, and today if you come to see, even established lawyers would want to be called as experts at economic offenses. So having said that, we are probably at the same cusp as a society at large, and looking at the changing landscapes of our country and the offenses which are being committed, and the intention behind the entire prosecution as well as the commission of offenses. Mediation is going to play a huge role, is in my humble opinion, when it comes to practice of a criminal lawyer in our country. So why am I saying this? So if you look at various crimes, say SFIO, which I already mentioned, which is investigating an offense, or any fraud which is committed, essentially, be it irrespective of the number of offenses which are committed or the volume of money which is involved in it, essentially it will come down to section 420 of the IPC, because it is about defrauding people, it is about cheating people. So when you see section 420, and if you correlate it with the criminal procedure code of our country, it is a compoundable offense in the first place. So I hope you all know what is a compoundable offense, but if you don't, it is an offense. 420 is an offense which can be compounded at the behest of the complainant with the permission of the court. So what does it mean? It means that if it is essentially an offense which entails only individuals. It cannot be stated, even if per se it is considered as every offense is considered as an offense against the state. Cheating, an offense of cheating cannot be considered having a societal impact as such. It is more of an impact on that individual which has been defrauded or cheated. So the law has allowed it to be compounded legally. And what does that entail is that if at all, say as a lawyer, you're facing a litigation, criminal litigation in which allegations of fraud or cheating or economic offenses are envisaged against the two corporates, and you're representing one of the parties, mediation could definitely come into picture, because eventually it's all about recovery of money. It is all about making sure that business goes on. And rarely is it about wanting to have the person behind the bars. Of course, in ego wars, it's the other way around. But more on a practical level, your clients are going to appreciate if you can mediate or you can find alternative dispute resolution processes to even settle their criminal disputes. The reason behind that is multifold. One is, as I said, on a practical level, it is going to be seen by most of the corporates, most of the clients, or most of the people who are involved in this type of scenario of criminality, that they would not want to disturb their businesses. They would not want to disturb their daily bread and butter, their daily peace of mind over a litigation which is going to transgress over, say, at least a decade, if not multiple decades. So that is always the practical standpoint of most of the people nowadays, that they would want to finish it as soon as possible. That's one part. Second part is that even if, say, two esteemed people, two reputed people do come across each other in a criminal litigation scenario, none of them is going to be spared, and they'll have to be facing the rigors of a criminal litigation, which entails an arrest, it entails defamation in the society, it entails staying in a very archaic sort of a environment of the central prisons. And it also entails losing your liberty, having sufficient control over it by the authorities, by the court, till the time the trial is getting over or it is being conducted, which in India is very slow. And third, as a continuation of the last point, the litigation process in India is excruciatingly slow. So, not commenting on the quality of it or the merit of it, but nonetheless, we are burdened with such great numbers of pending trials in our country that it is very difficult to have a justice delivery system which is very smooth and which is very fast. We always read while we are in colleges or we are just out of the colleges and entering the bar that speedy justice is everyone's right. But in India, at least, it's a distant reality. And having known that, and people now see that to be the reality, and they want to come out of the concerned allegations in a faster way. And that's the point wherein you can step in and propose alternative dispute resolutions. In such cases, arbitrations aren't possible as such unless it's a civil dispute in nature, but with criminal undertones. However, you can definitely suggest negotiations and mediations as a way to go ahead in such matters. One thing which you'll want to know and you'll have to keep in mind is that when you probably look at people who are legends at the bar, probably right now, so probably when they were starting out, when they were flourishing, the time was such that it was considered that lawyers should always focus on litigations. Lawyers should always support litigations. Lawyers should always make sure that cases are filed in the courts, and that because that's the only way you are going to survive or thrive. But I would like to differ from this opinion, especially now. The time is such that you can flourish irrespective of a case being filed in the court. You can flourish even if you propose that irrespective of a case being filed, you can actually go ahead and resolve the dispute beyond the courts. So always keep that in mind, that now you're entering into a world which is more focused on white collar crimes, virtual crimes, crimes which you can't touch and feel. And in such scenarios, the people behind them are going to be educated people. They are going to be people who want quick remedies out of it. And as a lawyer, you're in spite of choosing the field of corporate criminality, of criminal law, of litigation, mediation is going to be a part and parcel of your practice, and it is going to help you in giving more opportunities of working, of earning, and thriving and flourishing as a lawyer. So I hope I have summed out the entire scenario of criminal practice in India, coming from a time in which it was being drafted right from 1833 to 2020. This is the way in which criminality in our country is being changing. It will keep on changing, but unless and until you change with the concerned flow of the crimes that are being committed, the laws which are being made, and also the authorities which are popping up every now and then to investigate these offenses, unless you are very thorough with all the updates, you're very thorough with all the laws concerned, and you're open to the concept that I want to be a criminal lawyer, I can be a criminal lawyer in spite of not being very good or wanting to take bodily offenses, and in spite of not wanting to go down that lane wherein I would be questioning my conscience as such. As a lawyer, you shouldn't be, because it's not your job to judge anyone. But some people might face that difficulty, and their conscience might be stopping them from entering the world of criminal practice. But that's not the case now. And you can safely be at a situation wherein you can juggle both. And so that's about it, I think. Do keep in mind that mediation, even if it is not flourishing today, it is going to be the future, and you'll have to be very, very thorough with it. So another thing that before I end my interaction, another thing that I would like to add to it, that having said all of this, that bodily offense was the past, partly the present, and economic offenses, corporate offenses, virtual offenses are the present and future. One thing that I would definitely want to point to all of you, and which is a major part of the opportunities that you'll get in your life as a professional, is that you will have to be very good with your business sense. I have seen it that in the past, lawyers who are considered legends in our field will be excellent and godlike with respect to their laws per se, their acumen of law. However, they would lack the business sense of it. And in today's world, if you do not have that economic angle in your mind, if you do not have the business sense, you are not going to be an asset to your clients. Even in this setting, in the setting of a criminal practice, you are not going to be an asset to your clients unless and until here you have a very thorough business sense and you understand the business or the scenario from which the crime has been committed or it has cropped out. So your solutions have to be accordingly placed so that the people who are concerned or who are facing the litigation or who have approached you also get a practical hindsight of it, also get to live their normal life, and their businesses also thrive, and plus they get a legal remedy or solution from the challenges they are facing. So having said that, I think I'll close my interaction. If we have any questions, I'm more than glad to take them, Saurabh.
Yes, sir. There are questions in the question and answer. Can you open it?
Yes. So I can see, yes. For non-bodily offense, can you summarize which substantive laws or act are most important in the present scenario of society? So, firstly, even if IPC is old and I have disregarded it as something which is more with respect to bodily offenses. Even for non-bodily offenses, as I mentioned, even if it is say 10,000 crore fraud, the first section which will be charged will be section 420 of IPC. And depending upon the nature of the crime, other offenses around securities and non-bodily offenses which are mentioned in IPC. So you need to be thorough with IPC. That's one part. Second is that there will be multiple, you'll say if it's a corporate criminality, you'll have to be thorough with SEBI laws. You'll also have to go ahead and read various regional laws like MCOCA, which I mentioned. You will also have to be thorough with IT Act. You will also have to know other incidental acts which will have criminal undertones. So for example, it could be that a top corporate honko has come to you and he has been charged with a criminal charge of say sexual with a sexual offense which comes under say POSH Act, Prevention of Sexual Harassment. So whether it's a offense which is rightly committed or not, for you to be in a better position to be knowing it, you'll have to be thorough with that as well. So people majorly think that IPC is my goal and that's how I become a very good criminal lawyer, but that's not the case. You'll have to know all these allied laws as well. I'll take up the next question. What is a better opportunity for a law student, being an in-house legal advisor in an MNC or starting his or her own practice? First of all, I might sound a bit off track for the newer generation on this part. I strictly feel that everyone has to have a thorough learning experience in the profession. Before you end up being a legal advisor to an MNC, or you have your own practice, you become a partner in a firm, or you are a GC with any corporate, you will have to have your groundwork done very well. You will have to have your learnings done very well. With all due respect to the mental capacities of the newer generations and the exposure that you have got as you grow up, it is very necessary to get practical exposure in the profession and to learn the tricks of the trade before you start out on your own. So that's one part you need to focus on first, and then you can choose either ways, because nowadays both of these practices, being an in-house or a GC, or having your own practice as a firm or a practicing advocate, both sides of it are equally rewarding. Next, to be a corporate criminal lawyer, do we also need to be knowledgeable about IPR extensively? Yes, definitely. So as I said, when I ended my conversation, it was about having good business sense. So everything and anything which entails to do with a business, so IPR is essential part of any business entity. Unless and until their intellectual property right is protected, it cannot thrive. So if that is being transgressed upon, or it is being misused by anyone, essentially it becomes a part of criminal trajectory, and obviously cases of cheating and misrepresentation and defrauding, etc., are going to be filed, and you'll have to be in a position to understand from where have they emanated, and that's why IPR will be necessary. Next is what do you exactly mean by having a business sense in a legal profession? So as I mentioned right now, unless and until a lawyer understands from where the client is coming and how the crime has been committed, it's very difficult for you to protect or understand the grievance of your client in the first place, to protect him or give him sufficiently decent legal advice. So say for example, I am representing directors of IL&FS for that matter, or there was a famous case in the city of Pune wherein the college is situated, that a leading builder was accused of various criminal cases of taking the money of various investors and defrauding them. So in such scenarios, why am I giving these examples, is that you need to have the business sense when such a person comes to you as a defense counsel for that matter, that whether that money was actually taken to defraud someone or it was actually taken in the course of business, and it is just a case of not fulfilling your contractual obligations. So unless and until you understand the entire structure of the business, unless and until you understand the psyche of a businessman, you are not going to be in a position to give the necessary feedback or professional guidance to that person. And that's why that is what I mean by having a business sense. You will need to understand businesses, how they function, how does the businessman think, and what is it at the end of it that they are looking for, and whether the crime which is alleged is actually out of intention and mens rea, or it is a byproduct of failed business or non-fulfilled commitments. So that's from where I came with having a business sense. Did mediation work earlier in the case of bodily offenses, or such cases were directly solved in courts? So bodily offenses essentially even today are not mediated upon. As I said, criminal practice is not limited to bodily offenses, and hence mediation has become a very lucrative option for everyone. However, when it comes to bodily offenses, it is rare scope to have them mediated, because there are sufficient judgments of the Honorable Supreme Court wherein it is said that even an affidavit is given by the complainant in the court stating that he does not have a grievance against the accused once the trial begins, it is seen as tampering with the prosecution evidence, and it is not relied upon by the court. Therefore, it is very rare to see bodily offenses being mediated and settled out of court. Can you please give your opinion on how lawyers who are also company secretaries have scope in this stream of law? So for that matter, someone which has a background of being a company secretary will have a better scope if he is inclined in being a lawyer in this field specifically, that is of corporate criminality as well as mediation, because a company secretary by training essentially is groomed to be in a corporate environment. So if you wish to become a person who specializes in white collar crimes, who specializes in corporate criminality, you are already trained to be in the corporate scenario and the hierarchy. You understand it well, you have been in that field. So it becomes easier for you to mold yourself as a lawyer in that corporate criminality because you are from a business field. Otherwise, it becomes very difficult for quite a few people. I've seen promising lawyers who are very restrictive about their exposure to the business world or having business acumen, being handed over large commercial or large corporate crimes, and they miserably fail at it because they simply fail to understand how has the transaction transpired and what is the crime that is being alleged in the entire transaction. So that becomes a big misfit for them. And that's why CS are people who might fit in quite well here. What is the scope of inter-country economic disputes committed in India? What are the steps to getting such practice? So if you are in India, it entirely depends upon which country has registered the offense that you are speaking to be inter-country economic dispute or offense. So wherever the scope lies and you are licensed, so if it's a multi-country dispute or it's a multi-country crime and it has been registered in India and you are licensed to be practicing in India, that's the only scenario in which you can get that practice. Otherwise, even if it is a crime which has affected India, but the offense is say registered in Singapore and you're not licensed to practice there, you by no stretch of imagination can you get that practice. So it's all about being having offenses which are registered in the jurisdiction of the country in which you are registered to practice. That's the only scope of getting that practice. Can there be mediation? So that's about litigation. But if you are looking at mediations, you can of course practice all over the globe. It's all about your exposure. How exposed are you to people who will welcome mediation? So essentially that's the picture in which your exposure to the business world comes into play. Can there be mediation for non-compoundable offenses? If so, could you throw some light on it? As I mentioned, most of the non-compoundable offenses in our country are such which are of bodily nature, bodily offenses nature. So in such cases, it's very unlikely to have the offenses mediated, because the Supreme Court, considering the hostility of witnesses in our country to curb that, it has come up with various judgments which say that if a complainant, if the complainant also comes up with suo motu, with an affidavit stating that the complaint is something which they would not want to continue with, or if they were mistaken while giving the complaint, it is considered that the accused has tampered with the evidence and he has coerced the concerned complainant to come up with that affidavit, and hence mediation of such offenses becomes difficult. However, if it's a rare possibility of being a non-compoundable offense, it could be of, say, for example, forging a document which has a secured document is forged, so that becomes a non-compoundable offense. That can be mediated in a way that you can go ahead to the constitutional courts and invoke the writ jurisdiction to get it quashed. And since it won't be an offense which has affected the society at large, probably if you're successful enough to put forth your entire case, the court will be of the opinion that the concerned offense has to be quashed. So that's the way that you can approach it with by help of mediation. That's the limited scope otherwise. Is it still believed that criminal field is not safe for females, that there is no safety promised? How will you encourage someone who wants to be a criminal lawyer and is also a female to not worry about their safety? Definitely times have changed. I have great colleagues, juniors or seniors from the profession that I know who are females and they are thriving at the criminal practice. So it's no more the scenario wherein females won't be a fit in criminal field or it won't be safe for them. Of course, you'll also have to look at the practical standpoints. If you're coming from a place which is a smaller town wherein the law and order situation is of a issue, probably that's the only scenario in which you should take care as such. Otherwise, in bigger cities, and specifically if you are going ahead to be a criminal lawyer which doesn't do much of bodily offenses, that's absolutely a field in which you can thrive irrespective of your gender. And I think it's being a female is not a bar anymore to enter the criminal field. Can you please recommend some guidelines to prepare ourselves from now for this corporate criminal practice? I would suggest that even if you are in awe or you are passionate about criminal law as such and hence want to practice criminal law, slightly right now, if you're a student yet or you're just starting out to be a lawyer, deviate from it and start learning more of the corporate world. Start learning how do securities so say, how does SEBI securities function? How does SEBI function? Start learning how does a company function? Start learning how does a company function or a business operate? So if you deviate slightly and understand all these factions, you will be better adept when you are thorough with your criminal part of it. When you get cases, you will be very, very poised to be in a position wherein you can defend your client which has come from that segment. When you want to fall into the corporate criminality part of it, you have to be first knowing how does the corporate world function. That's the only way in which you can defend them in the criminal world. So just having knowledge of criminal law is not going to make you a good lawyer in the corporate criminality field of it. So start learning more about the corporate laws, start understanding the practicalities of the corporate world, and also obviously be thorough with your criminal law. That's the combination by which you can actually become a good corporate criminal lawyer. Even though there is a shift from litigation to mediation, or as you rightly mentioned, the importance of corporate crimes, do you feel that criminal litigation as it started from its inception till the near past has a survival in the future? And a person who wishes to be a criminal litigant in the old way or the present way has a great survival in future too? So frankly speaking, I don't see the litigation criminal litigation which thrived earlier to have much of a future. Because the law, as the country progresses, it is expected and it is seen world over that any country which progresses gradually gets a very good law and order situation. So for example, in a country like Japan, if you want to take an example, if you see various reports which have been made public by the concerned government, police over there barely have any work because there is almost nil rate of crimes, bodily offenses or crimes being registered. So when you see to it, that scenario, if not immediately, India as a country obviously will face that we keep on progressing and law and order becomes better and better. So if you consider that average length of a career of any practicing advocate ranges from 3 to 4 decades, if you start from today, three decades into future, probably bodily offenses is something you shouldn't be focusing on, because that cannot thrive in the future as the only source of criminal practice. So I think we don't have any more questions, Saurabh.
Sir, there are 3 questions in the chat box.
One second. So one is, why do you suggest mediation for a lawyer? So as I said, probably everyone must have heard that litigation is for lawyers. Mediation is not for lawyers, because unless people litigate, you don't get your fees. So that's not the case. You can get much higher fees as a mediating lawyer as well. People are going to respect and appreciate you if you can save their time. So if you get a client and you tell him to litigate and be in the court and waste his time for a decade, as against that, if you give him a solution which gets him out of the problem in 6 months, he's going to appreciate it and you are going to be rewarded accordingly. So that's the reason I have suggested mediation for lawyers. Next is, sir, please explain Santosh Mani case for IPC subject reference case. So essentially, the case of Santosh Mani was that he was accused of and convicted of taking a state transport bus from the bus depot in Pune and driving it randomly across the city roads, killing various people in a fit of rage, as was defended by him. However, the Supreme Court, so right from the trial court, the High Court and the Supreme Court, it was upheld that it wasn't the case that he was having any mental issues and that's how he has committed the offenses. It was considered to be done in a fit state of mind, and hence till the trial and the High Court he was given death penalty. However, in the Supreme Court, a petition was filed by his lawyers expecting to reduce the death penalty to a life penalty, which was allowed by the Honorable Supreme Court. Considering, so you'll have to understand here, what was the reason for getting the death penalty to life imprisonment. It wasn't the situation that it was the defense which was taken by the defense counsel that he was not of a sound mind and there was an iota of doubt. The only reason for which the punishment was reduced was that he was of very good behavior inside the prison for whatever years he was during the trial and the High Court petitions and the Supreme Court petition. And as you all might have rightly observed in various judgments of the Honorable Supreme Court, we also do believe as a country as a whole, and the judiciary of our country does believe in retributive justice as well. So if someone is showing retribution, if someone is showing scope of improvement, they do give him a chance, and hence his punishment was reduced from death to life imprisonment. At which stages of a dispute can mediation be used? Mediation can be used in any stage of a dispute, of course, unless and until it is gone to the final arguments and judgment of a trial, wherein once the judgment has come from the concerned court, it has to be taken care of and respected by everyone, and it has to be followed. So that's the only time probably you cannot interfere with the process and go ahead with mediation. Otherwise, right at the inception or once the offense is registered or during the course of the case as well, mediation can be considered, specifically, as I said, if it's a compoundable offense. And irrespective if it's not an offense which has been registered, obviously it remains as an option in all the cases. So will it be better to have done corporate non-litigation internship first, then turn to corporate litigation? Will that give more knowledge? Probably yes, you can get that added advantage if you have done a non-litigation internship. But as I spoke about the bridging of gaps between the criminal practice of from bodily offenses to virtual offenses or economic offenses, that's also been case with the so-called corporate or non-corporate and non-litigation internships. So even the corporate out and out corporate law firms that you see are into litigation, and the known litigation names are into corporate advisories. So now that has merged a lot, and it won't be as exclusive as it used to be earlier. So you can pick up any good lawyer or a firm which does corporate law. It's bound to be doing corporate litigation, or a good corporate lawyer is bound to be doing some corporate advisory. So either ways, it's a good opportunity for you to intern. Are there any programs or courses for law students on mediation and dispute resolution? Yes, various universities in the country, abroad, even the Ivy League universities have extensive and absolutely brilliant courses which you can consider for mediation and dispute resolution. For that matter, to be just so that everyone gets the practical standpoint of it, I have personally observed even judges of the Supreme Court, or for that matter, retired judges of the High Court who want to now again practice at the Supreme Court, actually going ahead and doing these courses at reputed Ivy League universities, because even they need to understand what is new in law and how do they flourish in practice once they step down from the bench. So that's the credibility of these courses. They are excellent in nature. You can go ahead and take them.
Yes, I guess that's it.
I think there are no more questions. There's one
Yes.
popped out in Q&A. Internships in this field can be experienced at. So I think I've answered that.
Yes. Over to Krishna, ma'am.
Am I audible?
Yes, ma'am.
Okay. Thank you, Saurabh sir. On behalf of Marathwada Mitra Mandal Shankarrao Chauhan Law College, I express my gratitude towards Dr. Chinmay sir. Sir, you have given the elaborative idea about the economic offences and then whatever the laws which are relevant to those offences, as well as the mediation. And definitely students, participants, they will be benefited out of your lecture and they will use this knowledge in the field. Thank you so much, sir. I express my gratitude towards Dr. Kranti Deshmukh, principal of Shankarrao Chauhan Law College, for giving us this opportunity and for a constant encouragement. I express my gratitude towards all the teaching, non-teaching staff of SCLC. And lastly, I would express my gratitude towards all the participants who have attended these sessions and yesterday's sessions as well. Thank you so much, sir. Now it's over to Saurabh, sir.
Yes, thank you so much, sir. So hope the students been enlightened with the speech that you have made. So we all are there on YouTube live as well. So I think in the Zoom we have more than 210 participants, and more than 50 participants are there on the YouTube channel. Thank you so much, sir. Yes, sir. Yes, sir. Over to Chinmay, sir.
Yes, pleasure to be here, and glad to have interacted with everyone. Always welcome to interact with young budding lawyers. So thank you for this entire platform that you have created for everyone.
Thank you, sir. So we also have Upendra Dulal, advocate from Nepal. So without further delay, we'll move ahead with the next session. So now I request Krishna ma'am to go ahead with the introduction of the speaker.
Thank you, Saurabh sir, again. For this session, we have with us eminent advocate, Advocate Upendra Dulal from Nepal. Sir has completed his graduation in law from Nepal Law Campus, diploma in international marketing and public relation from Leadership Academy, and post-graduation in international law from Wuhan University School of Law. Sir has published many articles in various journals on various topics such as arbitration, contract, and international law, etc. He has completed various training programs such as training program on international human rights litigation organized by TRI International, etc. During his student life, he was awarded with various awards such as Student Ambassador Nepal and India for student exchange program. Spirit Award, Manfred Lach's Space Law, Beijing. He was appointed as an international judge for Manfred Lach's Australia. He was also honored by Xiamen University as well. Currently, he is working as a senior advocate with Sinha Verma Law Concern and a visiting faculty at Asha Law College. Sir is a contributor in World Justice Project Rule of Index 2020. Sir is also associated with her college as an associate editor of SCLC Law Review. Without wasting much time, I now request to Upendra sir to proceed with the session.
Am I audible?
Yes, sir.
Thank you so much for this opportunity, and of course, thank you for having me in this webinar session. We were starting on my topic. I think I shall be thanking some person. First, I'll be thanking Marthwada Mitra Mandals Sankarao Chavankal. I think I spell it correct. Thank you for having me, and thank you for this opportunity. And it has come to my attention that the college has received A grade by the National Assessment and Accreditation Council of India, and I would like to congratulate the whole team for this award, of course. And I'm little in view of these students who are studying in this college, because in studying in such a great institution is always a pride. And of course, I would like to thank Pahu Sahib Jadhav sir, right, who is the executive president of this college. And of course, I would like to thank Principal Dr. Kranti, and of course, I cannot stand without saying thank you to Mr. Saurav. I know him since 2017. We were together in the Xiamen University for that summer school in international law. So it was a pleasure to know him in that day, and since then we know each other very well. I can say more things about Saurabh, but let's not talk about Saurabh today in today's session. Maybe I'll start with my issue. Like I have been asked to talk about international investment law and international opportunities from young lawyers' brain, and before that, I'll be saying one word about the place where I'm working. I'm working with the Sina Verma Law Concern as a senior associate here, and we deal with many more, foreign clients, and of course we deal about foreign direct investment and all. And I think it will be little easier for me to talk about what exactly investment is and what are the laws maybe that we have to go through when we talk about investment law, and what could be the opportunities that the young lawyers, or let's say a young student, can pursue. So let me start with my thing. Let me start with the investment, of course. And when we talk about investment law, we are talking about two things basically. One is investment, and the other is investors. So what is investment and what is investor? That matters when we talk about international investment law. Luckily, today I had a meeting with some investor, and probably that will be fruitful to share. I'll not be sharing all the things what we discussed, but I think I'll be saying some very, very, very briefly, so that it may help me to move forward also. Today, like we are talking about in today's meeting, we're talking about how the investments should be brought in, right, and what could be the procedures, and simultaneously what could be the procedure to get the visas and all, because these are all the associated issues and matters when we talk about international investment law. So what exactly investment is, what exactly investor does, is the primary concern when we talk about international investment law. Let me start with what actually investment is. Investment is all about investment is all about the commitment. Let's say commitment that the investor, commitment made by the investor in the expectation of a favorable rate of return. Like if I want to invest somewhere else, then what I will be expecting is like I'll be expecting the favorable rate of return. Then I will only be investing in any project. And the person, let's say if I'm investing something, maybe in cash or in kind, then I'll be regarded as the investor. And this is the very simple, description of what is an investment is and who is investor. And investor can be like the local investor and the of course the foreign investors. So since we are not talking about the local investor, we are only talking about the foreign investor. So when we talk about foreign investor, we are talking about the investment beyond the jurisdiction, beyond the local jurisdiction. Let's say if I'm investing something from Nepal in India, let's say you are investing something from India in Nepal, then that is called as a foreign investment. And but still, when we talk about the investment, we always try to frame a very concrete answer for this. Do we really have the perfect definition for the investment or not? That's the very first one comes in everyone's mind. But actually saying, we don't have the perfect definition for the investment. The investment has been defined in various ways, in various ways according to the let's say how according to the like whatever it is easier for the investors or the host state, it has been defined in the same way. That is why when we look at the different conventions also, we cannot find the perfect definition or the concrete definition of the investment is, but rather it has been left to be defined either by the bilateral treaties or through the for the arbitration panels, and all. They will be deciding like what actually investment is and what actually investment is not. But having said that, we cannot also escape from defining investment, what investment is. But in ICSID, in an arbitration case in 2001, ICSID has tried to define what actually investment is in the Salini versus Kingdom of Morocco, and that is also known as the Salini test. What it has tried to define investment. Sorry, the Salini case has tried to define the investment in a very four basic ways. First, what it says is like there should be a condition where an investor shall transfer the funds, which is like transfer of fund is the very first condition to define what investment is. Second, there should be the duration, like from when to when, or for how long the investment will remain in the host state and it will be investing for the project. So there should be first transfer of funds, then the second is the duration, and third is like they said there must be the involvement of risks. If I'm investing in a project, then it must involve a risk of what? Risk of protection of your investment, a risk of having simple in a simple way, risk of getting or not getting visa and all. So for these the transfer of fund, the duration, the risk, that are the three major condition to define something as an investment. And the Salini test has also given one more guidelines to define something as an investment. That thing is like the contribution to the economic development. If you are investing something, then it must gives you back something for the host state, not only for the investor but also for the host state, and that could be the economic development of that state. So what, according to the Salini test, what could be justified as an investment is, first, there shall be the transfer of funds. Second, there shall be the minimum duration. Third, it must involve the risk. Fourth, it should contribute in the economic development. Then only you can call something as an investment. Otherwise, that might not be called as an investment. This has the benchmark set by the Salini test, and it has been adopted throughout the period. When we talk about investment, then we have to talk about the law which will regulate the investment. So the regulating factor, let's say the law that regulates the investment is simply, like essentially, the investment law. Then what makes the sense of investment? When we are talking about the investment law, then we are also talking about the investor and the relationship between the investor and the host states. So what makes the essence of that investment law? So it could be, as I discussed earlier, just before like the Salin test, that the Salin test has demarcated the four conditions to define something as an investment. That four condition has made the essence of the investment law. First, of course, the cost, like how much investment you want to put in a project. Second, time, like for how long period you want to have that investment in a host state. Third, again, that risk. If you have these three things, like the cost, time, and the risk, then it will form the basic essence of the investment law. Because you are investing somewhere else, let's say in a host state, then you have to think about three things. Like of course, what will be the major cost you will be putting in, what will be the time frame, and if there involves any risk or not. So let's say that we talk coming to the essence, like the cost, the time, and the risk again. Every business plan of, or let's say, of a prospective investor, they involve a significant amount of money, or goods, or service, or human resources, let's say, for the economic operation of the project. So that can be considered as a cost in the investment scheme. And the second is like how much time, or let's say how much let's say there's an investment in Nepal, and they have put 20 years term for the project. Let's say that project will run for the 20 years, and it will be handed over to the government, which means it involves the fixed term period. For the term period, and for within that period, that project will run by the foreign investor. So the third thing is again comes with the risk. Like for investors, what they take is the commercial risk, like which inherents throughout the process. Like when you're investing money, there is a risk, like whether you'll get the proper return or not. So that risks are always with with the investment law. So we talk about the investment, we talk about the investment laws, we talk about who are the investors and all. So after that, maybe we have to know, like, what could be the sources what could be the sources of the international laws. Maybe you have read about the ICJ, International Court of Justice studied of the International Court of Justice, of course. And in the Article 38(1) of the ICJ, what it says is like, it talks about what the various sources of the international law. So based on that article, we can also draw the sources of the international investment law. It will definitely talk about it talks about what could be the basic sources of the international law. So you might have read about the treaties, 31 treaties. The second one is, of course, it talks about the custom international law. Third, it talks about the general principles, judicial decisions. These are the four basic sources of international law. But this international investment law. So besides that, international investment law, there are two other things that I like to state as the sources of the international investment law. So one could be like the unilateral statements produced by the host state, and the second could be the binding authoritative interpretation, and that binding authority interpretation could be produced by the arbitration tribunal like ICSID, like ICSID and UNCITRAL. So that could be the other two major sources of the international investment law. So have you ever thought like, since when this investment law has evolved and all? We have the practice of investing from one state to another, from not from olive, from this period, but from the olive period. When we talk about investment law, we started to think about uh, the modern investment that the countries are doing, but actually it is the essence of evolution of international investment law does not comes from the modern period, but it comes from the, of course, from the early period. And I would like to summarize these periods in the three stages. First, I'll be talking about uh, like first stage, I'll be talking about the colonial phase. Second, I'll be talking about the post-colonial, and third, I'll be talking about the global area till now. The first phase, I'll be discussing. I'll try to discuss about, like, as I said, like in the first phase, it will be a colonial phase. Uh, in early period, I'll be dividing these phases in, like, let's say, in 18th to 19th century, there were more the colonial power in the rise, and in that period, the concept of foreign investment started. I would say started from those days, and the protection of foreign investment was not a matter of concern in the colonial period. Why? It is because in those period, like, for example, British company, India was the colony of a British Empire in those days, and the East India Company was there. It was working in India, and it was not a matter of protection because it was already under the colony of Britain. So investment was there, but the matter of protection was not there. So it was not highlighted in a major way that, okay, that foreign investment is coming and all, and we need to protect on it. It was not looked in that, from that perspective, in those areas. But the reality is that was the foreign investment, because India was a country in that period, and England was the other country, and they came. Why they came to India is they came for the trade and all. And when they came for the trading, they came with the capital. They came with the capital, and they invested in India. So if you look at the scenario, the investment is moving from a country to the other country, which comes under the definition of the foreign investment coming from, or moving from, one country to other country, and investing in a project. Let's say a project, investing in a project, and they are working on it, and they're getting benefit from it. Where, just like in a contract, when we sign a contract, what we look for is, like, the two parties agrees for what? Two parties agree for a common agenda, and there comes the consideration. The consideration, in the similar way, in the international investment law, what happens is, like, a country, they agree to invest in another country, and what they expect from the investment is they want to take back something from that investment. But in the colonial phase, what happened is, like, they invested, but there was no, brief. There were no talk. There were no more talking about what exactly foreign investment is, what if it requires laws to protect it or not. This is how the whole investment scenario was moving on in the colonial period, and it was not a matter of protection and all, as I already said. And after that, but fortunately, what happened is, like, I think it was in the period of, say, 1700, I guess. US has signed a friendship, commercial, and navigation agreement, and that agreement was basically for the uh, protection of aliens' property in the land of France. So what it helps to make is a room, or let's say a space, to develop the international investment law. When we talk about investment law, we are not going to talk about moving of capital from a country to other country. It is also about the property which is already existing in the foreign land, foreign soil of an alien. So And what US did in 1700, I guess it's 795 or 96 like that. What they did is they signed an agreement where the France agreed to protect the aliens' property, and it helped to pave the route for the international investment law. Based on that, there were multiple agreement has been signed between more countries and all. And there's also important diplomacy was there in those period. That was the gun boot diplomacy. It was in existence at that period. What is the concept of this diplomacy is, yes, there were agreements signed, as I said, like 1796 US signed an agreement with the France, and France agreed to protect the aliens property. What if France disagreed to protect the aliens property, or what if France did not put much effort to protect the aliens property? What will happen next? So that was the that was the question always always comes when you talk about the international investment, when you talk about the development of international investment law. What after that, if France disagreed to protect the aliens property, what comes next is attacking over those countries. It used to happen in the colonial period. And when that attacking and protecting aliens property is actually comes under the gun diplomacy. After that, there were also the customary principle of international law, which was expected to protect the international investment. However, those customary international law were not adequate enough to protect the investment. There again comes the question why it is not adequate enough to protect the international investment. It is because, as I said earlier, when we talk about the foreign investment, there comes first where things comes is the security or the protection of that investment. If there is no security, why somebody will be interested in investing in the other countries? They would rather find the place which is more secure and protected. But this was the major concept, major concept which always hindered in the protection of the investment law. Despite of having customary international law and all, this was always in the frame to consider. And likewise, after the colonial period, it was existed till the Second World War. Until the Second World War, there were colonial period and investment were lessly protected because it was in the colonial countries. Investment were in the colonial countries and all. But after the Second World War, the colonial system starts to fail. It starts to fall, and there comes the issue started to raise about how we shall now protect the international investment. Because let's say, for example, if that's the same example which I was talking about, the East India Company. In East India Company, I'll not be going on the other parts of the East India Company, what happened in the historical facts and all, but I'm just trying to figure out the conceptual part only for international investment law. Let's say East India Company, they invested in India, and with the fall of colonial system, now the investment put by the East India Company is now in a risk, because it was protected under the British system, British laws, legal system in those days. And without having a proper laws and all, it will be a great concern, like how to protect the investment if there is no colonial power in the existence, and if there is no proper law in the existence. This will always put a dilemma for the investor, like how they shall be investing. So this is the same thing happened, and fortunately, I would say, this helped to develop the international investment in the international sphere. International investment plus international investment law in the international sphere. Because this imperial powers started to fall, and they started to looking for the, as I said, they started to looking for the protection of the foreign investment. This was the basic reason why the general agreement for tariffs and trade was concluded in 1947, because the trade started and the trade was in the peak, and they wanted to protect all the trades and all and the investment. So what they settle down, what they come up with, the idea is they'll be having GATT, and which will be protecting the foreign investment for foreign investment. And what did the international investment scenario also changed from bilateral agreements to the multilateral agreements, because when there was a colonial power, there were, you know, more, there were the existence, there is the existence of more bilateral agreements. But with the fall of colonial power, what happened is, uh, now the states started to move beyond the bilateral agreements, and they started to take over the multilateral agreements. That is why I think that was the reason for having a trilateral agreements between US, Canada, and Mexico. Yes, they had, I think that was the first trilateral agreement that happened in the international investment sphere. And this is how, you know, the colonial period, the post-colonial period was helped in the development of international investment law. Similarly, you know, it was in 1946, you know, which I was I think it's 1946. As I said, like, there were more bilateral agreements came into existence. I think there were more than 2 dozens of agreements that came into existence to regulate the international investments. And I think it was only the US who signed more than 2 dozens. So now compared, the US did 21, then we can think about how many contracts that have been signed by the other countries for the investment. And in the to 1946, in the period of 1946, again, you know, there were specific treaties, or let's agreement, like, called Friendship, Commercial, and Navigation, which is also called the FCN agreements. You know, that agreement primarily, let's say, for the first time, they started to talk about equal treatment, because why we need equal treatment is because the colonial power has already fallen up, and the more independent states they have, independent states they started to swap. Now if you want to invest in a country, in an independent state or independent country, then you will be thinking about what will happen to my product. You know, if I'm investing in the other country, if I'll not get the equal treatment, what will happen to my product? So I'll be starting as a foreign investor. I'll be started thinking about, if there will be no equal treatment, what would be the reason for investing in the foreign country? So those are that is the basic idea, basic reason for putting, you know, equal treatment, constant protection, and similarly security to foreign nationals, because if you are moving into the foreign national, you'll be looking for your own security also. And of the major term, the most favored nation treatment, most favored nation, you might have heard about MFN. You know, these conditions were for the first time included in the FCN agreements in around 1946. So they brought up the drastic change in the international investment law, because in those earlier in 19 or earlier before 1946, we are not talking about in international investment law. We are not talking about equal protection and all. After 1946, we started to talk about the independent state, their more rights. We started to talk about equal treatments. We started to talk about constant protection. These things, you know, these things helped. I will again say these things help to pave the road for the international investment law, for the development of the international investment law. I think it was for the first time, you know, even the ICJ, International Court of Justice, what they said is like, if there is a consenting jurisdiction, then they could hear the disputes related with the investment, and they could also interpret apply the investment document. This happened for the very first time in this colonial, sorry, post-colonial phase. Similarly, the major incident happened in this colonial post-colonial phase was like in 1965 in this area, I guess. For the first time the ICSID was established. I hope you have heard about the ICSID. It stands for International Center for Settlement of Investment Disputes. When we talk about the investment, we cannot say that there'll be no dispute in the future, because you are investing not in your own country. You are investing in the foreign country, and you'll be signing agreement with either with the host country or with the organizations or something like that, and you may have to face disputes, because this, I think this is the nature of the natural beings, let's say natural beings or natural person. There will be either it will be healthy or not healthy. There will be disputes. If this is a healthy dispute, then there will be no issue in going for this. But if the dispute is not healthy, you have to seek for a remedy. So in 1965, around 1965, ICSID was established in order to settle investment related disputes. So this helped in this was gradually helping foreign investor, let's say not only the foreign investor but the international community itself, to slowly understand the importance of investment law, and importance of investment law, and that is why they started developing, they started to come up with the idea of GATT. They started to come up with the idea of WTO. They started to come up with the idea of ICSID, the similar like the UNCITRAL, like this. They started to go up with these phenomenon, and they gradually and slowly they developed the investment law. So up to, as I said earlier, also I'll be discussing about the colonial, post-colonial, and the global era. So I'm done with the colonial, post-colonial. I'll be dealing with the global area, like how how after 1980s, how there comes the drastic change in the international investment law. I'll be discussing on this global area. In 19 the most, I think in the late 1980s, the most important change was the completion of Uruguay round of GATT. It happened in 1994 and established the World Trade Organizations, and I'm sure you all are aware of the WTO, what it does and why it was with what reason it was established. But in a simple sense, I would be saying that it was established as a world body in order to regulate the international trade. Because when we talk about foreign investment, we are not talking about the movement of money, or let's say putting money from a country to other country like this. We are not only talking about it. We are also talking about the trades that happens between two or more than two countries. So there comes the WTO, because there was no need of the institutions like WTO or United Nations, the GATT, ICSID, and OECD earlier before the 1946. It was already, because the imperial powers, they were all taking care of it with either with the gunboat diplomacy or with their powers and all. But with the fall of all those imperial powers and all, the people started to look for the new room for the negotiation on investment law for the protection of foreign investments and all. So when you are trading from a country to other country, or you are having a trade or not, we are just putting a investment in for the development of a country and of the host country, then it also talks about it also needs a law. It needs a law to regulate those instances also. That is why in late 1980s, the era of international investment law drastically made the changes. And what helped for this drastic changes, of course, again, the WTO law. Sorry, WTO. And what happened? Adopting a WTO is a final solution or not? Again, that may comes in the mind. Or WTO may not be the final solution for the development of the international investment law, but what it has been doing is like it has adopted the process of globalization, and it has included the subject of investment along with the trade, and expressly included investment related issues into its jurisdiction. So with the process of globalization, the world become the narrower. The world come the world started moving. From, let's say, now we have lots of investment from India to Nepal in the energy sector. Not only in the energy sector, but in the other major sectors. What am I saying is like what made it possible? Yes, we have comparatively, Nepal and India are very closer, and investment might come even without this type of institutions or not. But we have now, let's say that we have now investment from the European countries, the Americans, and the other countries. So what made it possible? It is possible because the globalization process adopted by the institutions like WTO has made it possible. So it is same like in India also. In early 1960s, 1970s, let's say, India was a developing country, and it was looking for the movement of capital, and it was possible after 1960s and 70s, let's say. And after 1960s and 70s, the more capital started to move towards India, and the movement of capital was possible because it was possible because of the institutions which was existing. It was possible because of the institution like WTO, which was already existing in those periods. And they gave a way out for the investing countries to come to countries like India, Nepal, other countries, to come and invest. So the globalization process, and of course the putting itself into the issues, or let's say the jurisdiction of investment, it gave more room for the development of international investment law. WTO has WTO has I would say, like, they have come up with the different ideas like trips, the trips, and dispute settlement bodies within itself has again given space for the development of international institutional law. And as I said, like around 1965, the Asian economy started to grow at a large extent. And I think you also need to look why foreign investment is coming to Asian countries. I would say more to the Asian countries is because we are rich in resources, but we are not rich in the capital. And now we are, of course, becoming the economic powerhouse. We have now started to get more capital, and we have started to move our capital from Asian to the other countries. We have just started, but in that in the early 1960s and till 1996, the capital started to move in, and more bilateral agreements started. Let's say more bilateral agreements, they started to came into the picture. Those bilateral agreements and the movement of capital in this global area, this is now giving a very good picture for the development of the international investment law. I would say, like, an agreement called NAFTA. NAFTA was signed in between US, Canada, and Mexico. Why it was signed was, first, it was a trilateral agreement. The world started to move from bilateral to multilateral first. Second, they started to look for the protection. Third, they were looking for the guarantee of the investment. And the fourth, they started look for the economic development, which eventually or substantially again started to prove these salinity test things which I discussed earlier. These events, these incident, they gradually started to let's say they started to help the development of the investment law. uh, talk, Talking about what actually investment is, who are the foreign investor, and how it started to develop. I think I covered that part, and I was also asked to talk about international investment law and the opportunities. So I'll be highlighting about uh, international international opportunities through international investments. First, I would be talking about, if there will be more for investment, there will be more job creation. As a young lawyers, what we are always trying to uh, look is, if after graduation, if I'll be getting job or not. That will be the basic or very fundamental things that comes in the mind of everyone when we think about after graduation. So if there will be foreign investment, of course there will be the more job creation. For example, let's say uh, if a foreign investor is investing in the energy sector, so who will be the primary person to be benefited is first the host country, second the locals over there, third, when you are investing your money in the energy sector, you'll be developing the energy of that country. There will be the more work for the engineers, and there will be the more work for these uh, of course for we lawyers. We will be negotiating, and we'll be coming with the final agendas for the settlement and all. So there'll be more beneficiary, I would say, if there will be the foreign investor only in one sector. One sector. This second would be like the uh, there were other investments, like also like investment in the first could be like infrastructure. If I'll give a scenario of Nepal on this on the infrastructure part. In the city, we still do not have a metro, and we are planning to have let's say the government of Nepal is planning to invite investors to invest in the infrastructure part. So when there will be the foreign investment, what will happen is, like, the country will have that infrastructure and could be a part of the economic development of the country. Second, you'll be doing you'll be bringing money. When there will be more money, there will be in the market, there will be the money will flow from one to other parts. And when the money is moving, there will be the creation of more jobs, and you'll be uh, let's say you'll be doing the DPR of the project. First example could be, and the second is like investing in that in that DPR, and the work for the engineers for that project. There could be more other opportunities. There could be more opportunities which could be you know dragged out when we when we talk about investment. Similarly, there will be more opportunities in different sectors, like could be tourism could be one. Someone trying to speak, or I think is Kranti's, is he trying to say something, or
No, you can continue. No, you can continue.
Oh, okay. So, basically, as I said, what could be the international opportunities? I would say from the perspective of law student, what could be the basic or fundamental opportunities could be like you could be dealing with the foreign investors. You could be having more channels of networking uh, away from your country or outside the country. You could be a foreign legal advisors. Like if you have a multinational multinational company coming to your country with a foreign investment, then you can be the legal advisor for them. Or you can have you can relocate your location, and you could be going here and there and giving the services and all. I think these could be the international opportunities that I could see for now from international opportunities. So from the part of international investment. I think Saurabh, I think
Yes.
these are the basic ideas that I wanted to put on the floor about.
Yes. So we'll move to the question answer. So if you can open the Q&A, there are 3 questions so far that we have received. So we can have a discussion on this.
But the first question is from Kumar. Okay, what type of industries do investors are willing to invest in countries like Nepal as of today? Now, I would say like till now, we are getting more investments in the energy sector, and we have like a large investment in the hydropower and the solar energy. So my answer is like more investments are coming in. The foreign investors, they are more interested to invest in the energy sector. The second question is the now hazing of investment work in international investments. Could you please share this? For this, uh, can you please clarify like how you wanted to portray your questions on the
Okay.
the regarding hazing?
I think he wanted to link it with the foreign investor risk management, probably whenever we talk about the hedging of the investment. So I think in an Indian perspective, we have a specialized regulation, that is the Securities and Exchange Board of India, that is SEBI. And basically we have a SEBI's regulation. We call it as an AIF regulation. I think it's a alternative investment funds regulation. So that basically have this idea regarding the hedging of the investment and to whom that we can
Okay.
have the marketing in the hedging investment, right?
Okay. Okay. Maybe I misunderstood earlier.
Right. So we can move to the next question. Yes.
No. It's okay. I'll say something about hazing,
Yeah,
like
sure.
how it is done in the context of Nepal. So hazing is basically, it is done for industry with foreign loans and all. So in the context of Nepal, if I have to say that it is I think he's also talking about how it is being done in the international investment. So it is being regulated through the central bank, like we have Nepal Rashtra Bank in Nepal. So the hazing is controlled, or let's say it is governed through the international investment is through NRB, I would say. So third question is, what should be the future course of action for a student completing his undergraduation from India? What should be the future course of action for a student completing his undergraduation from India who is aspiring to practice at international level? So I would again say, like, if you have a if you're really willing to work in the international level, then when you'll start exploring like what could be the basic what could be the area that you want to work first. Like even in international investment, there could be the more areas that you may need to explore. So after exploring those areas, like as I think in my presentation also I talked about the MNCs. If there are more MNCs in India, I think there is one basic. The other examples, I think I heard in yesterday only that Google is investing some amount in India, and it will be like Google India, something like that. So that could be a one possible, area that you may explore if you want to practice at international level. Can you specify some acts of investment law? Of course, if you're talking about acts, then in Nepal we have Foreign Investment and Technology Transfer Act, that is we call FITA, and we have recently enacted that the new one. We also have PPP Act, and the other act could be the Industrial Enterprises Act. Similarly, we can also we have like the NRB Acts, banking, and there are various laws that could be seen when we look for the investment laws. The hot money. I have heard the term hot money in the news many times, so wanted to know what does it refer to. But I haven't heard about hot money so far. Yeah.
I think it's something like short-term returns that you get on the interest. So basically, you have
like,
to invest in such a market that within a short period of time you get a maximum interest out of it. So I think that is something is more popular in the United States, I guess. So I think that is the question probably.
Yeah, okay, but I haven't been deep into this particular issue.
Right. Uh, I think
And basically, we also in the context of Nepal, we do not have this hot money things, and also that's the reason I'm unaware about this topic. So I think this is also one research area for me.
right. Is Krishna ma'am there?
Yes, sir.
Yes. Over to you, ma'am.
Okay, so I couldn't start my video. Okay. Okay, thank you so much, sir. I express my gratitude towards Upendra Dulal, sir, for having this wonderful session on the investment law. Thank you so much, sir. I express my gratitude towards Dr. Kranti ma'am for giving us this opportunity, and I would express my gratitude towards teaching and non-teaching staff of the SCLC. And lastly, I would express my gratitude towards all the participants for listening very patiently all these sessions. Thank you so much all. Now it's over to you, sir.
To me or so?
Yes, Upendra sir.
Okay. As I said in the very beginning of my presentation, before my presentation, thank you again for the entire team for having me in this international webinar series, and giving me a chance to speak about international investment and saying though I didn't say much of my experience, but maybe in future I could say more about my experience, like how we are practicing investment laws and how we are bringing for investment in the country. But for now, I will say thank you to the entire team, plus of course to Saurav for bringing me here and giving me a chance to talk, to say some few words about investment law. Thank you again.
Thank you, sir.
Thank you so much. Kranti ma'am? Kranti ma'am?
Hello.
Yes, ma'am.
Am I audible?
Yes,
Sorry,
yes,
I was on another official call. That's why I got late. And now I resume. So I hope the lecture is ended, and we are very thankful to Upendra sir. You have given very insightful guidance to our students, and in spite of very long distance, you could and we could approach to you and first time we interacted with you on such a topic. I can also see the response from participants that they are very happy. They have put so many questions in front of you. You must have found it difficult also to answer all those questions. So on behalf of entire family of Shankara Chavan Law College, I convey my heartfelt thanks to you. And second thing means this is my what we can say last note of this particular session. Today we are also celebrating birth centenary year of Lekshi Shankara Chavan. Shankara Chavan is the founder president of Marathwada Mitra Mandal, and today he has completed 100 years of his birth anniversary. And we can say, or we will take this opportunity to speak 2 minutes about Lekshi Shankara Chavan. He was former Home Minister of India and former Chief Minister of Maharashtra. Twice he served as a Chief Minister of Maharashtra. And with his great vision, ideas, and principle, he established Marathwada Mitra Mandal Institute in the year 1967 in Pune. The basic object behind this establishment was to provide a education to needy people. We all know that Marathwada is a drought hit region in Maharashtra, and where infrastructural and educational facilities are very less. So sir wanted that students from these areas, they should come and they should take education, and for them he provided free accommodation facility and education facility too. But over the period of time, it was not, this institute was not limited only to the students from Marathwada region, but we gradually spread our wings and we reached out to all the students who are in Maharashtra, in India, and we are now also looking for international students also. So now we are not limited, this institution is not limited only to the Marathwada region, but it has spreaded its wing entire nation, and slowly we are moving our things to international level also. So it was possible only because of his vision, his ideas, his support, and dedicated efforts by the other management member. So I take this opportunity to offer our tribute to Honorable Lekshi Shankara Chavan. On this moment, we definitely would like to remember him, and I would like to assure you that principles, ideas, and vision which he has set before us, definitely we will cherish it. We will try to implement those things in our institute also and in our work also. So thank you so much, all of you, for this for attending this international webinar. Once again, I would like to thank to Upendra sir, previous speaker Chinmay Bhosale sir, coordinator of this international webinar, Saurabh sir and Krishna ma'am, and all attendees of this international webinar. Thank you so much. Now over to you, Saurabh sir. Sir, your mic is off.
Thank you so much, ma'am. Thank you, Upendra sir. So we'll end up with this today's session regarding international webinar. The rest of the information for tomorrow's session and the feedback forms will be available on our Telegram group. You can also visit your YouTube channel, SCLC Carpet. You can subscribe it. We were live streaming today. So this is for the day. Thank you. Have a nice day.